Let's take a peek at the sealed documents that are so needed to be sealed. They're so needed to be sealed that the defense gave them to the media. Today, we are going to catch up on some of the things going on in the Kouri Richins case. They are beginning the very initial phases of jury selection, which means they are going through all of the questionnaires. We heard the judge talk about how many questionnaires that he was sending out, and it was like thousands of questionnaires. So they're going through all the questionnaires, and in going through all the questionnaires, they are going to start going through who's coming in to do in-person voir dire, or as Utah allows for, Zoom voir dire, which I don't even understand. Jury selection is scheduled to take 2 weeks in the Kouri Richins case. The judge is not doing jury selection on Friday. It seems like they're going to start in person on the 11th, but trial begins the 23rd. Today, we are going over the defense's renewed motion to reconsider change of venue. The defense is also alluding to the fact that the prosecution is threatening witnesses. So we're going to talk about that as well. This was filed January 26th. Kouri Richins, through her attorneys and the rules of Utah and Giglio, submits. It's like, hey, you have to give us information. Submits the following motion to compel the disclosure of all recorded calls, voicemails, text, or any type of digital messages from the prosecution team or any of their investigators and or investigators from the sheriff's department and or private investigators or process servers with any witness subpoenaed by the state to testify at the trial of the matter or any witness identified as a defense witness. Do you see the ripples of the Karen Reed effect? Law enforcement, I think, state over state, will forever refer to people getting into their personal cell phone as getting proctored. 100%. Because defense attorneys are paying attention. And defense attorneys in every state are going to be like, what might we find? However, there has to be a thread that opens this up. There has to be a reason this gets opened up. You can't just say, excuse me, Your Honor, I need everybody's messages with everybody. That's not proper. A lot of it's work product. So I'm curious what their thread is as we get into this motion. In support of this motion, the defense submits the following. Last week, the defense team received notice from one of the state's witnesses, witness 1, that she was being harassed by an investigator working with the prosecution and inquiring whether there was anything we could do to protect her from them. The witness forwarded text she received from lead detective Jeff O'Driscoll. Well, that's interesting. Also, it sounds like you already have them. So do you need them? The witness forwarded text she received from lead detective Jeff O'Driscoll, attached here to as Exhibit A. Guess what's sealed? Ding, ding, ding. The defense filed Exhibit A under seal and then gave it to other media outlets. As the court can see from the attached texts, the witness made it clear that she did not want to be quote unquote prepped by the state to testify and asked them to send her any of their questions in writing. They're never going to do that. Also, a lot of prepping a witness for trial, also not improper. A lot of prepping a witness for trial is, hey, just answer the question that's asked. Answer truthfully. Do you want to review any previous reports or statements that you made? We're going to call you to testify on this day. Please wear appropriate clothing to court. This court considers appropriate clothing to be this, that. When you are called to testify, it might be this day, but it could be a different day. This is the person that's going to contact you. This is where you park when you come to court. This is where the waiting room is when you are a witness and you're not in court yet. If you are a witness, you cannot watch this case streamed or whatever. You can't walk into the courtroom while somebody else is on the stand. You have to wait outside. There's a lot of logistical things that go into witness prepping. It is not a, so tell us this. It is a, this is how this all works. Detective O'Driscoll respond by threatening to get a warrant and arrest her and bring a pole for her dog if she did not come in for an interview. Okay. I feel like there's more to that. He also threatened witness 1 with jailing her. This is blatant witness intimidation. I have questions. You can't issue a body attachment for somebody not coming to an interview, though. I really wonder if this is, no, we're going to subpoena you. You are under subpoena. You have to come to court on that subpoena. And if you don't, we'll give you a ride. Where do we balance explaining to someone the consequences that actually exist and threatening them? It's really hard over text because where is the tone? However, you have been subpoenaed. If you do not show up, this is what's going to happen. I can understand why somebody would not like those consequences, but that's also reality. The defense has now received communication from another state witness also complaining of being harassed by state investigator Travis Hopper and asking the defense team for assistance. Texts from investigator Hopper were produced and attached as Exhibit B. I bet those are also fucking sealed. Apparently, witness 2 thinks investigator Hopper threatened to withdraw the previous immunity granted to the witness and submit him to prosecution if he does not agree to come in and discuss his testimony in person with the prosecution team. If you have been offered immunity and you fail to go to court and testify, guess what? No more immunity. However, I don't think they can do that for witness interviews. I don't know. Can Utah subpoena for witness interviews? Maybe they can, but generally this happens if you don't go to court. They say, finally, the fact that representatives of the prosecution team are threatening witnesses to coerce them into doing or saying things they did not want to do or say goes directly to witness credibility, and to the state's knowledge of these threats must be disclosed. The defense is requesting the court to compel the prosecution to disclose any and all text messages, voicemail, recorded calls, emails, or any other digital messages with witnesses identified by either the state or the defense on their witness list. All communications with everybody. No, that's not going to happen. And it sounds like they have the digital communications of the witnesses that they're concerned about, and it sounds like they're aware. And when the witness testifies, you can just say, have you talked to the prosecution before your testimony here today? This is from KSL.com. Kouri Richins claims the state is threatening witnesses and seeks all communications. In a motion filed Sunday, Richins' attorney asked 3rd District Court Judge M to require prosecutors and their investigator to turn over all messages. They supported the claim with screenshots of text messages from 2 witnesses. How would they know that they're screenshots? They're sealed. One who communicated with lead detective Jeff O'Driscoll, the other who communicated with the prosecution's team lead investigator Travis Hopper. The emails were provided to KSL by the defense. Richins' attorney Catherine Nestor said one witness reached out to defense attorneys saying she was being harassed and asking the defense team if they could do anything, quote, to protect her from them. She said that the witness made it clear that O'Driscoll said she did not want prosecutors to prepare her for the testimony and asked them to send questions in writing. The response from O'Driscoll said, quote, "You have received a subpoena to appear at the court as a witness." That's not for an interview, then that's for trial. That's true. "You have received a subpoena to appear in court as a witness." Fact. "If you fail to do so, the judge will issue a warrant for your arrest." Fact. "You will then have to sit in a holding cell until you are needed to testify." That's accurate. "So make your life easier and answer our calls so we can prep you on what you will be asked. Otherwise, the next time I knock on your door, I'll have a warrant and a catch pole for the dog." I mean, you can't just leave the dog home alone. But also, I really want to know if this witness said, yeah, come onto my property and see what happens. Also, witnesses don't have to answer the phone. Make it easier on yourself and just answer our calls. We can tell you what you'll be asked. Yeah, they don't want to talk to you. He also did not provide a date she would need to come to the trial when asked, instead telling her to show up to the court every day of the trial, February 23rd through March 26th, because she had not replied. That's information the defense provided to the media. Also, that's how that works. It's an option. Here's what I'm hearing. I'm hearing that this witness was given an option. Hey, you can answer our calls, but if you don't, you've been subpoenaed. Generally, witnesses are subpoenaed for the first day of trial. And if you were subpoenaed for the first day of trial and you don't show up, then you issue the body attachments. And if you're uncooperative and you show up the first day, here's what the attorneys will do. Excuse me, Your Honor. Witness name is present in court on subpoena. Can you please order them back to court for tomorrow? Thank you. And then the court will look at witness and say, witness name. You are hereby ordered to appear in court tomorrow morning at this time. We will see you back here tomorrow. Failure to appear is a violation of the court's order and you may be held in contempt. Sanctions for contempt can include custody. And then at least they get the option to sleep at home for the night. And then if the witness is not cooperative, they will order them back and trail them every single day of the trial. He did not provide a date she would need to come to trial, right? Because if you tell them we need you to testify on Wednesday and they don't show up on Wednesday, it fucks your whole day. Deputy Summit County Attorney Margaret Olson said prosecutors will respond to the motion privately through the court, declining any public comments because the case is close to trial. The prosecution's like, nah. Let's take a peek at the sealed documents that are so needed to be sealed. They're so needed to be sealed that the defense gave them to the media. This is a text from no idea what date it is. Everything is redacted. I know you think you have nothing to do with this case, but here are the facts. You are a material witness in a murder case. You have received a subpoena to appear at the court as a witness. If you fail to do so, the judge will issue a warrant for your arrest. You will then have to sit in a holding cell until you are needed to testify. So make your life easier and answer our calls so we can prep you on what you will be asked. Otherwise, the next time I knock on your door, I'll have a warrant and a catch pole for the dog. I need to know the history behind that. I don't need to be prepped. Give me the time and date and I will appear. It's on your subpoena. Is there more an exact date or do I need to be there February 23rd through March 26th? We could have discussed that if you ever replied, but since you don't want to, you can just plan on showing up every day at 8 a.m. And then it looks like it continues. I would like it over text message so that I have exactly what you say in writing. You are legally obligated to show up on the dates and times on your subpoena. This next one says Tuesday, December 30th at 11:28 a.m. At your request, I really need to set up a meeting with you to court prep you with the prosecutors. You are welcome to do it over Zoom, FaceTime, whatever. We just need to get you set up. Please respond. You can ask me whatever you'd like to ask me over text message. I do not want to be prepped. I do not want to be paid. Witnesses aren't paid. Sometimes you get a voucher for lunch. Whatever you'd like to speak to me about, you can send it through messages, not through county sheriffs. You guys are some blood-sucking, unfeeling people. So go ahead. What? I'm wondering if these messages precede the other messages, because the other messages just say today. I wonder if these are out of order. And it looks like a screenshot within a screenshot, or a screenshot within the text maybe, because these are smaller. Our calls so we can prep you on what you will be asked. Otherwise, the next time I knock on your door, I'll have a warrant and a cash bowl for the dog. I don't need to be prepped. It's on your subpoena, more specific. So it looks like that's screenshotted. So then, so go ahead, what? And then a screenshot and then crazy, period. Exhibit B, between witness 2 and Travis Hopper. This does not have a date. The person is saved as Travis Detective. Hi, Travis. I've already given a statement and I'm not interested in talking about this any further. I understand your position and acknowledge that you have previously provided a statement. However, I want to clarify that the immunity granted by the prosecution remains conditional upon continued cooperation. Declining to participate further may place that immunity at risk. Accordingly, your cooperation is still required. Please give me a day and a time you can stop by the sheriff's office so I can discuss the issues at hand. Honestly, Travis, everything I have to say, I have already spoken and provided you with a document for everything you asked. I've been 100% forthright and cooperative, and I will continue to be cooperative. This interview happened nearly 2 years ago, and rather than take the time out of my busy day, what further questions do you have? I also want to add that when we met, I was told by everyone in the room that I had done nothing wrong. Even so, I will continue to be cooperative. This is not going to count as witness intimidation. The defense is allowed to ask these questions when the witness testifies. A quick minute to thank today's sponsor, Lola Blankets, because not only are they my favorite blankets, but also it has been so easy having a cozy blanket that is also machine washable without getting all weird. And if you want to make sure everybody's cuddling up with you on the couch this Valentine's Day, you might need to gift yourself a Lola blanket. You might want to get a Lola blanket that matches your paw nerd. Or if you are thinking, who is the friend that just immediately buys everything for themselves and I can never pick a gift for them? Lola blankets are perfect because it is a slice of luxury that they might not have thought of for themselves. But once you gift it to them, you will also notice how much they start gifting Lola blankets. It's literally the softest blanket I've ever owned. I love that Lola blankets come in a wide variety of sizes, so you can pick what's right for you. So if you're looking for a way to send a hug this Valentine's Day, a Lola blanket is a perfect way to send that comfort to the loved ones in your life. And for a limited time, you get 40% off select Lola blanket products when you use code LAWNERD at checkout. Just head to lolablankets.com and use code LAWNERD. Also, let me know which blanket you pick. I love the green one. I think I need it for the chair behind me. Let me know. Do I need it? I think I do. After purchase, if they ask how you heard about them, let them know it was the Emily Show. Case briefs. Wrap yourself in luxury with your Lola blanket. Let's get back to today's show. Defense motion to reconsider change of venue. Kouri Richins, through her lawyers, asked this court to reconsider the defendant's motion to change venue. This is the first time the trial got put over for an extended period of time because they took this all the way up on appeal. And the Court of Appeals said, no. I also think the timing is appropriate. It's very hard to determine if you really can't have a fair trial in a particular venue until you start hearing from the jurors. And if every single juror comes in and is like, oh, I know about her, then you have a problem. And you might have a venue, you might have a location that has been so tainted against the defendant that they cannot get a fair trial. However, just because someone has heard of the case doesn't mean they can't be fair. Somebody could be like, oh yeah, I heard about that, huh? And not everyone in a jurisdiction is going to have heard of a case. Media has become much more personalized. And there are going to be some members of the jury pool who have curated their feeds that they don't see any of this shit. In the defendant's original motion to change venue, the defense argued that there was a reasonable likelihood that a fair trial cannot take place in Summit County, which is the standard set forth in State v. James. They go on to say, now that the court has responses to the jury questionnaire, it's obvious that Ms. Richins does not have a reasonable likelihood of a fair trial in Summit County. What would that mean if the court were to grant this? What would that mean? It would mean that the trial would have to be moved to a new court, and it would mean that the trial would be continued at a minimum, probably 4 or 5 months, maybe more. It would push this trial out. Could be up to a year. The survey conducted by the defense last year determined that 79.8% of Summit County residents recognized the case before the court, so they've heard of it. And of those, 49.1% had been following the case either very or somewhat closely. So of the people that had heard of the case, less than half of the people that had heard of the case had been following it closely. The actual numbers that are now before the court are higher. Of the 1,723 questionnaires that were returned, 1,472, or approximately 85.3%, recognized the case. Okay. Of those that recognized the case, 884, or approximately 60%, followed the case either somewhat or very closely. During oral argument at the April 17th, 2025 hearing, the court stated as follows. The court, I guess what I'm saying is, why wouldn't we focus on the 200 that don't recognize the case to start with? The court said to the defense, I'm willing to consider throwing out every juror who had ever heard of the case, which actually I think the state could have an argument against, saying actually that's unfair to take a jury pool that is informed, has heard of the case, and throw them all out. Shouldn't we just take out the people who had followed the case closely? And the court was like, no, I'm willing to. I'm willing to throw out every juror who said they'd ever heard of the case, which is further than I've seen a lot of judges go. A lot of judges are like, okay, well, if you've heard of the case, that doesn't mean you've made up your mind. Miss Lewis, the other defense attorney, not Nestor, Lewis said, so we're going to strike every single person who said they've heard of the case. The court said, well, that's your decision, not mine. The defense agrees that it is most appropriate to strike all jurors who have heard of the case, which leaves 251 potential jurors. However, most of these jurors answered other questions in a way that would immediately strike them for cause. But Your Honor, Of those 250, we hate all of them. When those jurors are removed, we are left with approximately 72 potential jurors. I mean, that's more than what, 8? They get 8 on this case plus alternates. Even if they doubled it, that's more than 16. In coming to the number 72, the defense removed jurors who indicated that they had hearing problems, were taking medication, or had impairments that left them unable to serve. Further, jurors who indicated that they could not follow the law, who could not be impartial, or who were not able for the trial dates, new witnesses, had beliefs against resolving disputes in court, or indicated no to answer question 93 were also removed. That's wild. Come on. This is not what this is for. This is for people who come in and are like, I have read every document. I've watched every hearing. I know everything about this case. Bloodworth, how's it going, my guy? Judge M, in love with you. Kathy Nestor, don't insult us that nobody lets a breakfast sandwich sit for more than an hour before they eat us. Come on, girl. We've all done it. Stop, I'm offended. Those are the jurors that they don't want. Fine. Jurors who know everything about this case and are like, there's no way I can be fair. I know too much. But to kick every juror who has indicated that, yeah, in a courtroom, it might be harder to hear, so I need the witnesses to use a microphone. You're going to encompass people who are trying to be forthright with the court, who are trying to be honest, and who are like, I don't know, sometimes I can't hear when my kid's talking to me, so do I answer that question, yes or no? You're going to encompass so many people, although there is no magic number as to how small a jury pool or venire can be. Under Utah law, the jury pool must represent a fair cross-section of the community. The smaller the pool, the less likely this to happen. Further, to seat a jury of 8 with 4 alternates, the court must qualify 43 jurors. When starting with a pool of approximately 72, the chances that this can happen are little to none. The reason they say they need at least 43 is because of the peremptories each side has. As argued previously, the standard for a change of venue is not simply a numbers game. The question is not, are there 8 people in Summit County who are qualified to serve as jurors? If this were the standard, there would never be a change of venue in any case. The question is there a reasonable likelihood that Ms. Richins can get a fair trial in Summit County? With the juror questionnaires in hand, it is clearer than ever that the answer to that question is no. For the reasons stated herein and the reasons set forth in defendant's original motion to change venue, the defendant respectfully requests that the venue in this matter be changed from Summit County, Utah to Salt Lake County, Utah. They really just want to go to Salt Lake. Let's see what the state has to say. State's memorandum in opposition to motion to reconsider venue. The state requests that the court deny defendant's motion to reconsider change of venue. The questionnaire responses strongly suggest that a fair and impartial jury can be impaneled in Summit County. Indeed, the questionnaire responses largely track the data that the court relied on in deciding change of venue. The motion's misrepresentation of defense counsel's discussion with the court during the change of venue hearing does not create a new legal standard or truly shrink the number of viable jurors. Among the 80% of Summit County residents predicted to have read, seen, or heard something about this case, 73% have no connection to Eric Richins' family, 31% have not formed an opinion regarding defendant's guilt. Of the 69% that believe defendant to be guilty, 50% believe that defendant would not have a difficult time convincing them that she is not guilty. Let's talk real quick about that. The way that the survey frames that question is then used for the argument, see, Your Honor, they say the defense would have to prove it to them. The defense doesn't have to prove anything. These jurors need the defense to prove it to them. And that's not the standard. But that's the way that the question is phrased. The questioning is, would the defendant be able to prove to you? It's in the way that the question is written. Ask better questions, get better answers. That question gives them something to fight with. It gives them room to say, see, Your Honor, they need us to convince them. We don't have the burden. On June 6th, the Utah Supreme Court denied the defendant's interlocutory petition for permission to appeal the ruling. Of the 1,723 juror questionnaire responses, 830 potential jurors report that they had never heard of the case. If you can't find 8 people out of 830 potential jurors report that they have never heard of this case and or followed the case, quote, not at all. 681 have followed this case only, quote, somewhat closely. Out of 1,723 jurors, 1,511 of them are like, meh. If a potential juror can and will act fairly and impartially, they must be passed for cause. Contrary to the motion, the court never stated in its discussion with defense counsel that it is most appropriate to strike all jurors who have heard of the case. No, the judge asked it as a question, is my memory. The judge was like, is this just what we do then? If this is a problem, do we just strike everybody that has ever heard of the case? The court's like, is that what we're going to do? The court did have that discussion. The court didn't say, I'm going to, but the court asked, could we do this? Conclusion. The court should deny the motion because a fair and impartial jury can be found in Summit County. Look, if you can't find a fucking jury of 8 plus 4 alternates out of 1,500 people, you got bigger problems. We do have reports that the court ruled on this on Monday, even though it's nowhere on the docket. Attorneys for the Camas mother accused of killing her husband have long argued that the close-knit Summit County could not guarantee Kouri Richins a fair trial. They doubled down on that notion January 30th, arguing in court papers that the trial should happen in Salt Lake County, because 85% of the 1,700 Summit County residents queried said they knew about the case. It was the second time that the attorneys have asked for a change of venue. The judge denied the request February 2nd. Monday, defense attorneys and Summit County prosecutors met with the judge to whittle down the pool of prospective jurors based on their questionnaire responses. Those remaining will be called for in-person questioning starting February 11th. The original scheduling order has February 10th. The court might have changed it. Utah requires 8 jurors and 4 alternates. In court papers, the Summit County Attorney's Office said it only makes sense to think twice about moving the trial if, after verbal questioning, the parties can't find 12 suitable candidates. I think that's fair. Jury selection is expected to conclude February 18th. Also, at the February 2nd hearing, Judge M extended the length of the trial by 2 days, March 13th and 20th. It's still scheduled to begin February 23rd and end March 26th. As we head into the Kouri Richins trial, which is truly beginning now, the Kouri Richins trial is taking all of the 1,700 plus jury surveys. Those were mailed out, they completed them, mailed them back. From that group of over 1,700 surveys, the court and the attorneys have sat down and said, we need to take these out. Individuals who cannot be on jury duty during that time because they're traveling. Individuals who are like, I know everything about this case. Let me tell you about docket 214. I have opinions and more. All of the attorneys are going to go through that together. They're going to reduce the number of surveys to a jury pool. And then they are going to start bringing jurors in groups in the veneer or the pool to start to narrow it down to pick a jury of 8 deliberating jurors, 4 alternates. No, on this case, Utah does not deliberate with 12. 8 jurors, 4 alternates. Jury selection is scheduled to start on Monday. The court has indicated that they are not going to run jury selection stuff on Fridays. I imagine that until we get to opening statements, the judge is going to use Fridays the way that the judge did in Depp Heard. Judge A used Fridays to go through motions, to prepare what needed to be cut out of depositions, etc. So I imagine the court will use that as working time or to handle their other cases, because even though court is going to be in session for trial, the judge still has a full docket, and oftentimes judges will use that day off to handle other motions and keep other cases moving along. So the jury selection is scheduled to take about 2 weeks. That's how long the judge has set aside for it. And opening statements should be February 23rd. The defense is still trying to get all communications between the prosecution, between the investigators, the sheriffs, and everybody else, and any potential witness that they're going to call in this case. The judge hasn't ruled on that yet, and the state's response is under seal. Funny enough, the defense exhibits were also under seal and then provided to the media. So why did you seal them? So we've not seen the state's response to that. We do not know what the state's response to that is. And there's no rebuttal in the media because it was leaked. And I have very strong feelings about that. If you didn't want to seal the documents, don't seal them. But if you wanted to seal them, don't provide them to the media. I imagine that the judge will deny that. I'm curious if the prosecution will bring up the defense's providing of that information to the media. I imagine that they should. If the court were to take that up, it would be something taken up after trial. The defense is not going to get admonished, sanctioned, or anything like that by the court before trial. Now, the court might say, what are you doing? Don't do that. And it is wild to me that on a Sunday, the defense is filing that motion and providing it to the media, yelling that the sky is falling and the prosecution is intimidating witnesses and everything is terrible and they need all of the communications, and then turning around a couple days later and being like, but Your Honor, we don't have an adequate jury pool because they've all heard about this case. And the court denied that when they were in court Monday. I have to wonder if when they were in court Monday talking about the juror questionnaires, this came up. Very curious if this came up. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.app.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.